Okay, so I think it makes sense for us to go ahead and get started. I thought I would introduce myself and my co-presenter. I'm Robin Wilson. I'm on the College of Law faculty and co-director Epstein Health Law and Policy Program. I'm also the new director at the Institute of Government and Public Affairs for the University of Illinois System. In that capacity, this has been a super interesting time because COVID-19's had so many different impacts on the state. And in the kind of work that we're doing, monitoring that, Carl Brigette's, my co-presenter, and I have been intersecting at different points. So this is a wonderful opportunity to share with you some perspective that both of us have coming from different places to what's happening during the pandemic around public health law and basic systems. Carl, you're going to be presenting first, but let me just first say, Carl's been teaching in the Epstein program and at the College of Law. We're so delighted to be able to partner with him. He's one of our alums and has just finished up a terrific class, I understand, from our students that had a lot of really hands-on information. And it's been a super interesting time to be teaching, obviously, for every obvious reason. Carl, should we take over there?
Sure, let's get right into the slides so that we can move through. As Robin said, it's an interesting time to both be practicing in healthcare and also studying and teaching it for obvious reasons. If you look at this slide that we created to try to track, it's already out of date. We created this in June in preparation for the class, but in 1 month's time, the numbers have gotten considerably worse in some metrics. What are some important dates to highlight is just how quickly this moves and how we're studying in real time this true pandemic, which started at the tail end of 2019 in China, where there was the first report of a case to the WHO, and then the first death just 2 weeks into January. There was a declaration, and we'll explain a little bit more about this, but there was a declaration of a public health emergency by the United States on January 31st. That was just right after WHO declared a global health emergency. And, but it wasn't until March that the states in the United States started declaring statewide emergencies, and that the president, after many of these states, including Illinois, declared a state emergency, declared a national emergency in the United States. The distinction between his declaration of a national emergency and the public health emergency that was declared by the HHS secretary back in January is something we'll get a little into. But you see that in the last row there of this timeline, this very sad timeline, we see that we've gotten to the point in the world at the end of June where there were 10 million cases. Now there are 17.3 million cases worldwide. So an additional 7 million cases were added. In the United States, it went from 2.5 million cases and 125,000 deaths to 4.6 million cases and 150,000 deaths. And in Illinois, there were about 179,000 cases, which there were 140,000 as of last month. Around the same, more deaths, but still in the 7,000 range. Obviously, a lot of that is due to more testing, both nationally and globally. And the various actions that were taken by private sector entities, health experts, and governments in a patchwork way, which we'll get into, attributes a little bit to the decline in the rate of increase in deaths over this period of time. Let's go to the next slide. Looking at the actions that have been taken by governments, which is a large part of what we're going to be talking about here today in my section, is that Illinois did take relatively early action and a stay-at-home order and other public health waivers and initiatives. And we experienced a peak in late April, early May. And there was talk, and there's still, if you look at the data, that by June we had flattened the curve. And there was a movement by the state government to revise executive orders and declarations. Other states around the country, as is well documented at this point, but when we were putting this together, it was a little bit of, I wouldn't say speculation, but prognostication that southern and western states had not put in the panoply of orders that Illinois and certain other states had, or they had gone back to what has been called reopening their state's economy. And was thought at that point in time, and it's proved out to be the case, that was done prematurely. And as a result, we saw not a second wave really, but a continuation of the first wave in places that hadn't flattened the curve. Let's go to the next slide. So what we're going to cover here, I just wanted to give a little historical context, even though we're only talking about the past 8 months, but that's the context for talking about learning about public health during this period of time. We're going to look at the quarantine laws and issues, the stay-at-home orders and how they sort of fit in with the quarantine laws, waivers of liabilities. We're going to talk about specific cases relating to how different groups and stakeholders in America view vaccinations, waivers of liabilities, all sorts of issues, mask wearing, of course, and how in America that has really become a political issue, and it continues to be a political issue, which then translates into a public health problem. So first, though, we're going to take a look at what public health law is and a little bit about that. I don't know how many people in this particular class have that much experience with public health, but it's a good time to learn it and to review what are sort of the general principles of it. And I think the second quote here really encapsulates it, which is what we as a society do collectively to assure the conditions for people to be healthy. In the context of an emergent situation like we're faced with here in a pandemic, or if there's an outbreak that's more localized, it ends up becoming a real legal issue and a political issue, which is the tension between the collective and the individual. As we see here, public health by definition is what we collectively have to do and what is determined by polities, whether it's a state government or the national government. But there are individual concerns that always arise, and that's where legal issues and lawyers come in, and it's important, and we're seeing it play out in really painful terms here in the United States because of the effects on people due to that tension. Next slide. My apologies for continuing to say next slide, but someone else is Heather's controlling this. So the topics we want to cover is the overview of public health services, the core values and ethical decision-making framework that operates within that, rationing care and what that is and how that plays itself out in real-world terms, public health emergencies, patient rights and provider obligations, the laws related to isolation and quarantine, and then risk and management and crisis management when we find ourselves in such a situation. The actors that are involved in public health law. This is important because by definition, this is an intersection of public and private. There are many entities, persons, stakeholders, government actors that play a large role in these decisions. The government has this role and authority and power to establish laws, provide emergency orders, prioritize even outside of the emergency situation, prioritizing policy decisions when necessary, calling upon private actors to yield to the public good. Providers, healthcare providers, hospitals, doctors, nurses, NGOs, work on mobilizing response efforts in reaction to or at the direction of government at times, because the government, especially in an emergency situation, can't act on its own. It has to operate through private actors. But that occurs even in a non-emergent situation where you're talking about public health, is that there are all sorts of private stakeholders and private actors that are help facilitating and effectuating the policy that the government sets out. Next slide. So I want to talk a little bit about what the government's authority is and sort of from a philosophical and legal jurisprudential standpoint where this emanates from. So American government in a state of normalcy. Normalcy in America could be considered a constitutional liberal representative democracy. And there's feedback here. Are you getting? Let me know if there's any problem with my audio here. In the normal situation, we do put a preeminent value on due process and individual rights in America, as much, if not more so, than any other country on the globe. We have a written constitution that documents how processes should work. There's a Bill of Rights attached to it that protect individuals. We are a liberal institution in the classical sense, a liberal country in the classical sense, in that there are negative liberties that protect the individual from state action. And it therefore results in our culture being one that puts a preeminent value on individual autonomy and freedom. In addition, jumping down a little bit, federalism is that our system of government is constructed so that there is a lot of power that's been devolved to the states and localities. And that is viewed as a good from a standpoint of liberalism, but when dealing with public health issues, particularly emergencies, that can present some difficulties. Next slide. The tension that I was talking about before comes from the individual focused virtues and values that our country and our culture puts a preeminent value on, with the community oriented interests that have to be at play when we're dealing with public health issues. We have to, in other words, respect independence, privacy, and agency of the individual, but we must balance that with community concerns, and particularly in a pandemic, emergent community concerns. And justice and fairness as virtues demand that we review both individual rights and community interests and weigh them. The other thing I do want to note in terms of this tension that goes on in American culture and in American law and politics is that suspicion of government vis-a-vis private interests. It's a hallmark of American culture, and we see it all the time. There's plenty of good scholarly writings on that particular issue. The national and state authority is in tension. Again, with a federal system of government, there is so much power that is shared with the states. It's a heavily matrixed, if you will, governmental system. And there is, again, I'm noting here, suspicion and lack of trust in the federal government as part of American culture. Next slide. And before I'll halt on this side for 1 second and just note that there are other countries on the globe, of course, that have federalist structures. Germany is one that I like to highlight that has they have different states, if you will, within their country that a lot of power is devolved to, and then they have a central authority. So they have a similar sort of setup and constitution. Now, what underlies this is the state of emergency situation, which I just described was the normal state of affairs for government and law in America. But in a state of emergency, it's often noted that law and standard process and substance that is valued is suspended by the sovereign to preserve law and order and safety until normal institutions and processes can be restored. That can sound like a very controversial statement, especially given what was in the news in the past 24 hours actually about this. The idea that we have to achieve security and safety before we go back to quote unquote normal. Those are the hallmarks of state of emergency kind of language. Where does this emanate from? This actually emanates from ancient Roman legal principles. Justitium is what it is called, which is just the idea that in a time of invasion or civil war or famine, which happened quite often in the Roman Republic, or an interregnum period between rulers, there often would be called upon an individual to have supra or extrajudicial authority to, for a limited period of time, conferred upon by the legislature to re-achieve or to restore order and law. And then it was prescribed that that person would step aside and allow the democratic processes to resume in the Republic, at least. Next slide. So the question that I have here, and I could stop here to just see if there are any questions about this, is our liberal democracy, with its emphasis on due process and individual rights, and with its federal structure, which devolves so much authority to localities and states, is it well equipped to handle a crisis that threatens significant harm to the public? And that's a question that illustrates the problem here. And I'll wait to see if there are questions that come in, and we can halt again and talk about those questions. But there is a form in America of justitium, if you will, in that there is built into our system of government and our laws, both at the federal and the state level, processes by which state of emergencies can be declared, and that agencies can be granted what would normally be considered extrajudicial, but they are judicial because they're prescribed by law, authority to go around what normally would be done for a period of time in order to restore order, or at least mitigate the problems that a emergency, public emergency or public health emergency in this case, might inflict upon its people. Now, I note here in red that given our federal structure with its emphasis on states' rights, and given America's legal and cultural emphasis on individual liberty, forming a unified response to a national emergency like a pandemic remains challenging. Normally, when you're talking about states of emergency, including even disease outbreaks, which have happened before, of course, they are more localized. A flood or a forest fires, et cetera, may cause a state to declare a state of emergency, and that would call upon a lot of different things to happen, including federal aid that comes into the state. But it doesn't require this unified 50-state solution and to address something that's bigger, like a pandemic. And so it is built into our system of government and our laws that there is an American form of justicium, but because of the structure in American government and the way that we devolve so much authority to states, localities, and emphasize individual rights, it is not exactly, it's never going to be perfect, but it's not even optimal necessarily when dealing with a pandemic. And this is I wouldn't say the first of its kind that America's had to deal with, but in recent memory, certainly. Next slide. So let's talk a little bit about public health emergencies. And this is from a legal perspective. So what are the public health emergencies that can be declared? The federal government can declare emergencies under what's called the Stafford Act, and it's when the president can declare an emergency, and it allows federal assistance to flow to state and local efforts and free them up to be able to, what's quoted in the statute here, save lives and protect property, public health, and safety. So built into the Stafford Act, built in the definition of a national emergency, is this idea of saving lives and protecting public health. At the state level, we have declarations of emergency, and they also, it's a little bit more broad, and there's a list of things, as you can see here, that could constitute an emergency, but it does include public health emergency. These statutes allow the executive at the federal level or at the state level to call the public emergency, to declare the state of emergency. And what does that mean? What powers are then conferred, and what things look different then? Next slide. These are the federal agencies that operate at the behest of the federal government and a president who calls a national emergency. There's the Army Corps of Engineers. In a public health emergency, you have HHS, you have CMS, you have the Centers for Disease Control, you have the Surgeon General, all of the public health services, and you have the Department of Homeland Security, which has FEMA. Now, FEMA normally has not been dealing with public health issues, more dealing with natural disasters, and it was called upon then and put under Department of Homeland Security when the Department of Homeland Security was created in response to the terrorist attacks. But we're finding for the first time that FEMA also has this integral role in public health. These are the different acts that exist that confer the authority of as I coined it, American justicium, and allow the president under the Stafford Act to declare national emergency, and the Public Health Services Act, which allow the Department of HHS, the HHS Secretary, to declare a public health emergency. And that's why I remember back in that slide when we were talking about the timeline here, we saw a public health emergency declared the day after the WHO declared a global health emergency, and that was declared by the HHS Secretary. It wasn't for another 2 months before states and the federal government ended up declaring a national emergency. So what's the difference? The HHS Secretary calling a Public Health Services Act emergency really focuses, as you would expect, on disease prevention and mitigation and the public health, infectious disease outbreak issues. There are things that can be done once that emergency is declared by CMS and CDC. And one particular thing that's in my wheelhouse as a employee of a health system are waivers that are provided under the Social Security Act, under Section 1135 of the Social Security Act, which really obviate the need for a period of time during the emergency for the government to declare for the hospitals and providers to have to follow the letter of the law when it comes to certain regulations like the Stark Act, or when it comes to complying with certain very strict rules that if we did violate them, or if we violated the letter of the law during a normal period of time, it might result in penalties or us losing participation in CMS. And that is lifted through these waivers. So that's really the difference between what the health secretary can declare and what the president can declare. Let's go to the next slide. These are the state authorities. There's a similar kind of chain of command, if you will. You have the Office of the Governor. His version of the military, if you will, is the National Guard. that can be deployed at the governor's direction to help preserve order and deal with public emergencies. Here, what's interesting is the National Guard, much like the Army Corps of Engineers, so it was in concert, helped in certain locations to build hospitals. In New York, you heard about the building or the conversion of convention centers, just like happened here in Illinois, into healthcare facilities. Alternate care facilities is what they were calling them. You have the Illinois Emergency Management Agency, which is the corollary to FEMA, and then a host of other alphabet soups at the state level that help effectuate public health and healthcare delivery and payment in Illinois. Next slide. The state's authority, very similar to the federal authority, is that the governor can declare, he has an emergency power under IEMA, which is the Illinois Emergency Management Act, to declare a state of emergency that is not in any way, by any means, confined to public health, of course. But that IDPH, similar to HHS at the federal level, can quarantine and order isolation, people to isolate, quarantine, et cetera, under the Public Health Act relative to dangerously contagious or infectious diseases. That's obviously what we have here in the coronavirus situation. So again, it's similar. These provisions that allow for states of emergency are similar in the way that they're structured and the chain of command works at the federal level as they do at the state level. Next slide. And I should note, here's 1135 waivers that I was talking about before, but I should note that when the president declares the emergency or when the governor declares the national emergency, regardless of whether it's public health or not, it does also allow for the freeing up of dollars that wouldn't normally be available to help states out and then states to help localities out in turn. Again, it's sort of a parallel and cascading effect if it works properly. I'll go back to the next slide, sorry. So 1135 waivers, don't want to get too in the weeds on this, but upon these declarations that were noted here, the national emergency declared under the Stafford Act and HHS declaring the public health emergency, it then permits on a temporary basis the waiver or modification of different requirements under Medicare, Medicaid, and that's very important for people in my world and those of you who are on the call who represent healthcare entities to allow us to operate and adjust in real time in an emergency basis and not get everything perfectly right. Not that anybody ever gets it perfectly right, but it's even more difficult during an emergency situation. And you'll notice there that it does require the federal government's, the president and the HHS secretary to have declarations of emergency declared in tandem. Those are conditions required before you have these waivers, which means there was a lag time of 2 months at the federal level between the president declaring a Stafford Act emergency, between the HHS secretary declaring a health emergency and the president declaring a public emergency, a national emergency. And you want to hope for more coordination. We can go ahead a few slides, I think, to the next one. You do want to hope, the hope is not a plan, that your federal government, all agencies and offices are coordinated so that they line up these declarations at the same time so you don't have gaps. And then again, you would hope that, and hope is not a plan, but the states would also be working in concert with the federal government. And I'll just note as a little bit of preface to this is that we saw and we're seeing in the news the results of having a patchwork system. These are the examples of the things that an 1135 waiver can waive or modify. And for those of you who are knee-deep in the weeds on healthcare law and fraud and abuse law, you see, as I said, there's a relaxation of different penalties and requirements under EMTALA, which is the law that requires hospitals to take anyone and everyone as when there is a maternal delivery that needs to happen or an emergency and a person has to be stabilized. It makes it sound like hospitals can do anything. They're still, we shift into emergency mode, and what it just allows us to do is to, whereas we might we might have to take in someone regardless of the situation at our hospital in a normal situation under EMTALA, if we are at capacity, we can find other hospitals to transfer parties to. So yes, and as you see there, EMTALA is the Anti-Patient Dumping Act. which would normally apply in all situations and require us to take everybody, but it allows us to triage a little bit better and localities to triage a little bit better to get patients to where the resources are, the beds are open, and where they're best able to take care of those patients in an emergency situation. Go to the next slide. So this is interesting here that, sorry, the slide before, real quick, is that there are blanket waivers and then there are individualized waivers. The blanket waivers are waivers that, and we don't need to go back to it, you can stop, it's just that applies to everybody, all healthcare entities across the country. But then HHS allows and CMS allow for individual hospitals or states to approach them and ask for waivers that relate to their particular situation. And so something more specific can be granted as well. So again, this goes back to this idea that there are rules and structures in place, if they're working properly, to handle emergencies, even though our system of government and its structure is, in normal times, not necessarily optimal for dealing with emergent situations. Here we have a slide that, I think the slide before, and I'll skip it quickly, is that the FDA, and this is important as it relates to vaccines, it allows for emergency use of certain types of vaccines where the process for getting a drug cleared, medicine cleared, is truncated. And that allows us to enact public health policies and hopefully get to a place we may be visiting that sort of a situation with the vaccines related to COVID. And here we have a slide that talks about, that's in front of you, about FEMA, which is that Federal Emergency Management Agency. And this customarily had not really been thought of and contemplated in terms of helping out hospitals, at least. Again, I'm coming from a hospital vantage point in dealing with emergencies. But actually, FEMA is going to be providing aid to hospitals and healthcare providers where the other tranches of money that have been provided will not be enough. FEMA can afford us funds to help us get through the crisis and continue to deliver healthcare on an emergent basis to people for as long as this pandemic persists.
Hey, Carl, this we should also ask, if we should ask periodically if we have questions, but it's interesting about FEMA because it really did come to the front in a public health crisis, which was Katrina. You know, I mean, we always think of them being deployed during a natural disaster, but given the way that Katrina unfolded, especially in New Orleans and Louisiana, FEMA was omnipresent on the ground, and they were managing what ultimately became a public health crisis. And I don't know if folks are sort of, you know, weather.com people like I am, but we have a hurricane hurtling towards the coast of Florida and all up and down the East Coast, and we may see that we're going to have both COVID-19 and a natural disaster. And how did those intersect? Because normally, you know, FEMA would be, you know, basically requisitioning schools to put people in. And yet congregate care isn't going to be safe right now because of COVID-19. So I think FEMA is going to be an interesting pincher movement where we look at the intersection of natural disaster and COVID. And I think that will be true in the next coming days. Are there questions, by the way, where we are right now? Covered a chunk of material. We're going to bring it down into some case questions in a few minutes, but I thought I would just ask while I had interjected. We good? Well, let's keep going then.
Sure. I notice we are halfway through, so I want to cycle through as quickly as I can here. The next few slides, Robin, so we get to some more specifics. The next slide. I want to highlight something on this next slide about liability protections, both at the federal level and at the state level. There is a mechanism, again, for the federal government and the state government to immunize private actors that are acting at the behest of government to assist in a public health emergency or any kind of public emergency. And that did happen at the state level, and we'll talk a little bit about that. In which liability waivers or immunity was granted for a period of time to those responding to the pandemic. Next slide. I think we can skip my apologies, but I want to make sure we move through. So we can skip the next few slides here and go to case law in a time of crisis.
There, yeah.
Right. So I just wanted to highlight some hallmark cases that many of you may know, but they take on a new point of analysis at this juncture. One is the Youngstown versus Sawyer case. This was a case that dealt with the attempted nationalization of steel mills during the Korean War. Really what this case is being highlighted here for is it's talking about the ability of the federal government to intercede in the economy, to order the economy, private actors in the economy. Again, we get to private and public. The public ordering the private to be deployed to do something at the behest of the government in order to meet a crisis. We saw this come up recently in the current pandemic when the Defense Authorization Act was actually not utilized. They did not utilize the laws here to compel private actors to make masks, PPE, or ventilators. There was bully pulpit lobbying done, and then there was the market forces itself just operating to generate PPE and ventilators. But it is within the power of the government in certain narrowly defined ways to order private actors to be deployed to build and manufacture things for the crisis to help ameliorate the crisis. Another important case in public health law that has repercussions for right now is Jacobson versus Massachusetts. And this dealt with when you think about it, relatively very small crisis, a smallpox outbreak in Boston. The state had required vaccinations, and an individual by the name of Jacobson had objected to having to be forced to take the vaccination. And the Supreme Court ultimately ruled that liberty, which is generally the virtue that the individual was arguing about, was not an unrestricted license to act according to one's own will, and that the epidemic of smallpox was a threat to public health, and the state had the authority in its police power to order the vaccinations. This case is, again, I think we're going to see this, we'll see litigation like this, Robin, in the context not just potentially of vaccinations once they're developed and disseminated, but also you'll see litigation, I'm sure, in terms of how people have been ordered in certain states to wear masks. Things like that. I think that we're going to see, and litigation's always a lagging indicator, because it obviously by definition has to happen after the fact. But we see, just as in these cases, which go back quite a ways, the same issues are going to arise in the current pandemic and post-pandemic, which people are going to have objected, or businesses might object to being ordered to do things and say that that interferes with their individual rights or their corporate rights or free market rights. And what is the government's authority to do something about that? The next slide talks about another case that deals with quarantines and equal protection. This is Juho versus Williamson, is where the city of San Francisco issued a quarantine relative to the bubonic plague around Chinatown in San Francisco. Yet it was almost gerrymandered around two people of another race who were excluded from the quarantine. And the court held that this was not permissible, and this is in the days before there was robust equal protection analysis and substantive and procedural due process analysis and jurisprudence that had been issued. But even prior to that mechanism sort of being set out by the courts, this is how courts were looking at these situations. Again, it gets back to the idea of weighing the individual's rights versus the community's rights, and making sure that to the extent we have to take action and force people to do things or confine them or force businesses to do things, it's narrowly tailored to a compelling state interest. The next slide talks about the Ebola quarantine case. And this case, while harrowing at the time, almost looks positively quaint compared to what's going on now, because if you look at it, there were only 11 cases despite the hysteria around Ebola back in 2014, 2015. 2 were contracted within the United States and 9 came from other countries. So we actually only had 2 cases in the United States. And yet there was a lot of hysteria about it. And this one nurse named Casey Hickox, who had been in West Africa treating Ebola patients, returned to New Jersey. She was from Maine, but she went through New Jersey. And she was ordered into a quarantine in a tent. Governor Chris Christie, who you may know of, made a big deal about it, and basically forcing her to not be able to have communications with people. There was question about legal counsel, whether or not she could even talk to her lawyer. There was no shower in the tent. It was really kind of looking back on it, it was a really sad moment where we got swept up in hysteria. Thankfully, not too much harm happened. She did ultimately move back to get to Maine. And Maine, though, issued some severe restrictions around her that she challenged. And she challenged both of these orders, and she largely prevailed. One was settled out of court. But it did establish for people who had rights in quarantine, like right to counsel, the right to sue while in quarantine, to receive communication from people, and privacy, as long as it doesn't interfere with vital public health needs. Again, a weighing of individual interests and rights against that community interest. The danger with the community interest is of course, the hysteria and the moral panic that can result when something like this happens. And again, Ebola, scary disease, but in America really was never as bad as it is in this current pandemic. And I'll turn it over to Robin on some other cases.
Yeah, so I just wanted to kind of tie some threads together by using something I've been writing about, which is the fact that churches have been meeting throughout the pandemic. Some of them politically, like, you know, the folks that are objecting to the mask saying, damn it, we have a right to meet, notwithstanding the governor's orders. And then how should we think of that as a problem? And it raises many of the same issues that Carl already touched on. So, you know, the relationship between individual rights and state rights. And of course, it's complicated in the sense that there are First Amendment protections for free exercise. And those have been cited by the churches in part because, you know, a lot of the orders shutting down the economy allowed essential businesses to stay open. And I think a lot of people of faith took umbrage at the idea that somehow worship was not made essential. They also cited their rights to meet. If you'll look at the next slide, Heather, thank you. You know, and cited not only the First Amendment, but many of you'll remember from Hobby Lobby and other sort of culture war cases, you know, their protections under state religious freedom restoration acts or state constitutions, which give heightened scrutiny to burdens on religious belief. And so their basic argument was, well, you're letting, you know, barbershops open, but you're not letting a church open. So how can this be constitutional, legal, whatsoever? And I think with all the drama that we've had since COVID-19 may have escaped your notice, but if you'll go to the next slide, Heather, may have escaped your notice that the Supreme Court just pushed back cert in a case called South Bay United Pentecostal Church. The Pentecostal churches in some parts of the country have had massive outbreaks. Some of the churches, you know, have as many as 3,000 congregants, and they've had 80 people sick at a clip. I'll show you a little bit more about that in a second. And Justice Roberts actually had to go through Jacobson and some of the other cases that Carl has cited, and denying the request for, it was an interlocutory appeal, but just saying that we're going to stay out until later in the procedure of that case. You know, he said that basically the Constitution is entrusting the safety and health of people to our governor. And I see Jenny Carroll in chat is asking about Bailey versus Pritzker. So we'll try to get to that if we can, Jenny. But there's tremendous authority put in our elected officials during a time of natural disaster or pandemic. And so the court just kicks this back and says, we're not going to look at that. Thank you for advancing for me, Heather, because that's where I was going next, which is, you know, it's an interesting question now, you know, as we slowly allow churches to come back, which Illinois has done, for example, saying that, you know, we'll apply the same rules to a church that we would apply to other large groups that collect together. So 50 people or less or something like that. We're now seeing that the whole shift to contact tracing means that we can actually follow these things back to the specific institution where the outbreak seems to have really gotten started, including in many instances churches. And then that, if you'll go to the next slide, takes us to a question of sort of the responsibility of those churches. And here's a recent piece that I did with some students in our LLM program and in the Epstein program about the possibility of churches being made liable. Carl mentioned that the governor waived liability for healthcare providers during the pandemic. That's under challenge. change. But at least there was, purported protection for people meeting and carrying out their business if something happens. We don't see anything like that put in place for churches. And the contact tracing is interesting because it can help establish that this thing happened there. So I think one of the things that will be really important is whether people are in fact faithfully following CDC guidance. And in this piece that I did with some students, as I said, we sort of dig down into that CDC guidance. Is it operational in the context of a church? What would it look like? What would services look like? And if churches aren't doing that, would they have access to coverage under their professional general liability policies? Some of you on this call may know that a lot of the insurers in Illinois have already sort of flagged their insureds and said, if you're not following the guidance from the governor and from CDC and other places, don't necessarily look to us to pay for any of the damage outside, or under those policies. And of course, commercial general liability policies don't pay if there's an intentional tort, and neither do they pay in instances of reckless disregard. So there would be a tremendous pressure to be following faithfully that guidance if you want not to have bad outcomes or to be made liable for those kinds of outcomes. And I think if we go to the next slide, that takes us to the next section, Carl, with quarantine and stay-at-home orders. Oh, but while I'm there, should we pause for a second? I know Jenny had a question. Do you know much about Bailey versus Pritzker, Carl?
So that's a case brought by a state representative, Darren Bailey, against Pritzker, and it alleged that and a state circuit court did rule in favor of the representative, and it alleged that the extension, essentially, of the state of emergency that was declared by Pritzker in March, so the April extension of it, was unconstitutional. The argument being that he did not have the authority to carry a state of emergency out ad infinitum, or at least past 30 days even, is what Bailey was saying. That local judge ruled in favor of it. It's on appeal. I believe that it's still pending that appeal briefing this month, maybe next month. In August. I think the question was, what do we anticipate? Is there any anticipation as to what might happen with it? I believe that the governor was in the right to do it. I think that this is a case of it's a political point that was trying to be scored. But it is a fair question as to how long a state of emergency can be declared without assembly approval or the consent of the governed. That gets back to that idea of justitium and how much authority does the governor have. It's really largely untested because these things are usually, like I said, states of emergency are usually more localized and time limited. This could go on for a year and a half. So it's a fair question to ask, even though I think it might have been a politically motivated case. I do think the governor will prevail because I don't know what the meaning of the state of emergency declaration, as long as it's supportable, and he can make a good argument, which I think he can, that's supportable, that there's a compelling state interest here. I think that he has the ability to withstand this challenge on appeal.
And Jenny, I'll just add to that. We're seeing across the country that those kinds of challenges haven't even been successful on round one. So I think, Bailey versus Pritzker is unusual. We're also seeing that the courts themselves are kind of coming back online. Of course, Cook County and others took temporary measures, would do temporary hearings, but the apparatus of the courts have kind of ground to a halt. And that's something that Jason Mazzoni at the College of Law and I are looking at now. And so I think as the challenges will come to be resolved, and I think it won't just be this question of the background authority of the governor. Each piece of these orders is also able to be challenged. So we know that people have already challenged the liability waiver in court. There are people on behalf of employees that want to say that the background workers' comp limited liability regime for injuries, that though that should not be disrupted, right? That we shouldn't allow employers to be operating what would be a quote unsafe workplace. And so I think every single one of these orders or devices is up for grabs. But I also think that, meaning that they'll be contested. But I also think what the Supreme Court did in South Bay Pentecostal is important, because I think they are going to allow this to work through the normal process. And while the governor has the control of the executive, we'll continue on that glide path. Now, God forbid, we'll see maybe in November that Trump takes the same approach to things and says, hey, I'm not going anywhere, whatever the people of America say, right? But it's an awesome position to be in as the executive, because to some extent, you can continue until an authoritative court says you may not.
Yeah, that's right. And it's also, I think, what's going to be born out of this pandemic, because it's going to be, by the end of it, knock on wood, it will have taken over a year or more to wind its way through. Everyone in America is being affected by it. And there are so many, like you said, Robin, so many different individual orders and things, both at the state and federal level, that undoubtedly will be challenged and will work their way through their courts, which are sort of backed up. And we will get a lot of law out of this, where right now we don't have a lot of law. There's a reason why, in the case you cited, Robin, the South Bay Pentecostal, they're citing to these cases from more than a century ago, because it just doesn't happen that often. And as a result, we're going to get some new or fresh law on it. I don't know how much it's going to say, though, that's that different than what was said in the past. And the reason I say that, I'm a little bit of a view that when you're dealing with public emergencies, as long as it's a bona fide, a rationally based approach to dealing with a public health emergency, I think the powers of the executive on this sort of state of emergency declaration and things they can do is pretty plenary. It may have to be when you think about it. It doesn't mean that around the edges there won't be challenges, like you said, with civil liability protection. That'll be one for sure. It is being challenged already. But let's look here at quarantine and stay-at-home orders. And I want to move through this very quickly because we're running out of time. There's a difference, of course, between isolation and quarantine. All should know that. And isolation is when a patient actually is infected, has the contagion, being isolated and separated from the rest of individuals pending their recovery. Quarantine is when people who have been exposed or may have been exposed are similarly have their freedoms and liberties restricted. A stay-at-home order is different than both. A stay-at-home order is really something that is not in the vein of, it's more similar to a quarantine, but it wouldn't meet the definition of that exactly. But it is an effort, a prophylactic effort by the governor to stop the spread and to allow for there to be catch-up by providers and things like contact tracing, other things to be done in an effort to slow the spread and get, if possible, ahead of the disease. But it still emanates from the laws that and the jurisdictional principles that where quarantine and isolation laws come from. Go to the next slide, please. These are the federal statutes that authorize quarantine and isolation laws. And broadly, look, if you see here, the Health and Human Services Secretary has the authority to prevent the entry and spread of communicable diseases from foreign countries. And then here between states, so there can be a lot of restrictions that are put in place. We have not seen that done by the federal government. Now, we did see, as Trump has said about the China ban, the travel there that he did do early in January. But recall that there were probably as big, if not bigger, problems in Italy. And the travel ban didn't apply there. So again, what we're living through and seeing in the pandemic as it relates to studying health, public health law, is that inconsistency both in the way it's structured, our patchwork structure for states of emergency and dealing with emergency, and in execution and approach and tone. Really makes a difference as to whether or not you can have a meaningful mitigation of a spread of a contagious disease. It really requires both a structure of laws and policies and the execution of policy and enforcement of those laws in a uniform way that meets the challenge of such a widespread disease. Next slide. I think here we're talking about state quarantine isolation laws. You'll have this deck, so looking at it, you can reference it for purposes of figuring out. Very similar, though, the authority here is with DPH to order quarantine, isolation, and closures, and that's where, in part, the governor and DPH, which he oversees, ordered the stay-at-home, and that's where it, again, emanates from. Next slide. And I think, Robin, like you said, there are going to be challenges to all of this stuff, especially if it persists. I mean, you saw, we just got 2 months into the pandemic. I mean, once it meaningfully hit our shores. And there were people already saying, well, the stay-at-home orders are extra constitutional. They have to be thrown out. In fact, in some ways, these things are extra constitutional, or at least extra legal. And that our law, we're not just that, they're not normal enough for us to be acquainted with the fact that they are built into our system in a manner of speaking. There just isn't a lot of practical case law on this stuff. These talk about the penalties that are associated with with isolations and quarantine and violating them. And, you know, we saw this when there was a stay-at-home and a shutdown of non-essential businesses, Robin, where the Attorney General in the state of Illinois went to prosecute, and you see this in other states, they prosecuted or at least threatened to prosecute businesses that were continuing to open. Because you saw in other states where, like, meat processing plants, et cetera, where there were outbreaks at these businesses because we pushed ahead with them. Next slide. Let's go through to the 2 more slides forward. This is just about the penalties associated with violations. Here, so we see how COVID spread. And it's so interesting. Rob and I were talking about this. We put this together in June. If we were to do it now, we'd start seeing the colors on the states would start flipping around. It's almost like it's a whack-a-mole, and it moved in waves. First, you know, you had it on the East Coast, in the West Coast, and then you had it in Illinois and Michigan. Then now you're seeing it in the South and West. You've heard now the South and West is starting to subside, and in Ohio and Wisconsin, you're starting to see peaks. What is the cause of that? I think that's a good question that has partly a legal answer, which is that different states did different things. They reopened earlier than others. Some stayed in play, had stricter laws for a longer period of time. You have cultural answers to these questions, which are, we did notice, if you looked at it, there was an interesting function in Google that you could look at people and their travel habits, and you saw that people in Illinois were not traveling as much as people in other states, or moving around as much. I think in Illinois, we had a combination of pretty strict and quick rules that came down, and emergency orders that came down, and I don't know if I want to say, go as far as say culture, but at least a populace that was willing to abide by them. I don't know if we're more rule-abiding than other states. I'm not sure of that. And you saw, as a result, Illinois being, I won't call it a success story, but more effective in flattening that curve and holding it there for a period of time, even to this day, based on the numbers that I'm seeing, although they're ticking up, vis-a-vis other states around us. Next slide. And here we see the different orders that Pritzker issued that relate to the school closings and the public park closing. You did also see, by the way, I'll let this slide speak for itself, but you did also see the municipality's intention, or at least divergent at times from the state. It's been pretty harmonious for the most part, but the city, for good reasons, again, rationally related or even compelling interest, that the city was faced with more higher risk of spread and more cases and more fatalities. So it took a stricter approach than maybe some central Illinois counties did. Next slide. This is waivers of liability. I will try to, Robin has already talked about that. The governor did issue an order which emanated from his authorities under the Emergency Management Act to say that hospitals, was interesting. He was essentially saying hospitals and providers were working at the behest of the state, because that's what the hook is, at the behest of the state to respond to the emergency. And as a result, they could be, under the Emergency Management Act, immune from civil liability, all but in cases of willful and wanton conduct. Now, what were they doing at the behest of the state? Was it just that they were taking in COVID patients? It was a combination of things. It was that they were taking care of COVID patients, but also that they were stopping elective procedures. And because they were doing that at the behest of the state, that was deemed to be essentially that they were like an agent of the state, and therefore, much as the state has sovereign immunity, there was immunity conferred for a period of time to providers about that. Being challenged right now, certainly plaintiffs bar none too happy with it. These are the statutes in which this emanates from. I already explored those. And next slide. And I think the next few slides just talk about what that order looks like, so we can slide over that. and get to these next two slides, which talk about the poised to reopen and what a difference a month makes, right? These were the states that were poised to reopen in on June 1st, 2020. Take a look at this. Take a look at this, and then think about what we know now. All these states were poised to, not just poised to reopen, they were reopening. That's the blue. Now let's go one slide further, because I think, Rob, and then we put in another slide that showed not even a month later, well, actually a little bit more than a month later. Here you go. It just was not coordinated. It was not coordinated. It was not uniform. And one could say maybe under our system it couldn't be. I would challenge that, because I think if the federal government wanted to take a more of a directive approach on this, it could have. But it chose not to, and then you saw this. Again, back to that whack-a-mole idea, just back and forth. And I think what would be an interesting study, Robin and others on this call, would be to look at, when all is said and done, the way people approached the law and enacted laws and emergency orders, and the data trends, and see whether or not there was, without a doubt, there's some correlation for sure.
Yeah, and I just hosted a call with IGPA scholars this morning. We're going to do exactly that. So because you have this differential, we're going to look at the Midwest as a kind of donut. The Midwest looks a little bit like a donut, and we're going to look at how the rules around Illinois differ and do cross-border comparisons, sort of city to city, to see, wow, is the difference here geographic? Is it the composition of the community? Or is it the policy itself? So it's a difficult problem to decompose, but that's what we're going to try. And I was going to talk a little bit here, and we're really out of time. So let me just say, I think where we're going to see a lot of pushback, and you're already seeing this, 48% of Americans saying that they're going to oppose the vaccine if there is a vaccine. Now, I wonder whether people would change their minds about this when there are. But for those people who want to oppose a vaccine, if you go to the next slide, Heather, there's actually a whole lot of protections in their camp. So this is a map from one of my recent books called The Contested Place of Religion and Family Law, but it shows how many vaccination exemptions there are around the country. And you can see, it's sort of interesting, it's a rare thing when you see West Virginia, Mississippi, and California in the same sentence as progressive and saying we're not going to have vaccination exemptions, but everywhere else does, okay? And I think there's going to be tremendous push on state legislatures to rethink those exemptions, because what's hanging in the balance is going to be, all of our well-being, because we may not get to herd immunity if we have widespread exemption use. If you'll go to the next slide. There's a long history of not treating of faith communities, just to go back to them, not treating their children. Interesting case out of the Alaska Supreme Court in the last week, where they refused to allow a woman to continue to care for her mother who needed care, physical treatment care, because she was refusing to treat. And so we're going to see a lot of contestation around this, I think. We are actually at time. I'm sure Carl would be more than delighted to stay with me and answer questions, but we wanted to thank those folks who've been with us for that. Thanks, Jenny, for her question. And we're delighted to just sort of, close up now with you and answer questions. Does that sound okay? I see Jackie shaking her head. Thank you. Thank you. Does anybody have questions? You can just raise your hand, throw them in chat, jump on, unmute yourself. Anybody have questions? Jackie, you're never so quiet. You have any questions?
I'm thinking and processing.
Yeah. Okay. It's been a real privilege to be teaching, at this time. I taught a course this last semester at the University of Colorado during half the course during the pandemic. Carl taught his course for us during the pandemic. And, you're watching, I think Carl's right, we're watching law be made. We're watching practice and law both be made in real time. And so it is hard to make that kind of predictive judgment that we were trying to make with Jenny about how will, the Bailey versus Pritzker case come out. But I think there's going to be tremendous pressure on the courts to allow the choices that are made to stand because we're in the middle of a crisis. So that'd be my predictive judgment. Carl, any last words?
No, I just there's so much to do, and it's unfortunate that because there's so many other issues that come up that there are almost literally real world examples for all of them that are taking place right now, and we're just going to see litigation coming from it. So I think in the next year or two, we're just going to see this is going to be an active area of law and an interesting one.
Mhm.
And unfortunately, I think it's going to be I think there will be another coronavirus at some point in time, and you see, if you look back over the past 20 years and then judge it 100 years before that, the incidence of respiratory diseases, at least, and things that they've been compressed because of global trade and movement and travel. It's going to continue to be an issue, and so to get the law worked out on this, I mean, it's never going to be perfect, but getting it worked out better than what we have it now, it's going to be critically important to public health.
Yeah, I think that's got to be right. That's probably a good note to end on then. So thanks, folks, for being with us. We really appreciate you. Nice to see some new faces. And I'm going to put my email in the chat. So if anybody has questions or wants to reach back to Carl, I'll flip that to his way too. And thank you for having us. And thanks for making us work through the slides, helping us with that.
Thank you.
Thank you, Carl. Appreciate it.
Thanks, Robin. Thanks, everyone.